Are you shocked by what the Supreme Court just did? Welcome to the channel Universal Insight. Please subscribe to my channel and press the bell icon button. Headlines tonight. Did the Supreme Court just shake up both gun rights and police powers with a blockbuster 9-0 ruling? There's a ton of buzz out there, but let's separate the facts from the hype. Alright, let's dive in because there's a lot of noise floating around, especially on YouTube, claiming a massive, unanimous Supreme Court decision covering both the Second and Fourth Amendments. The truth? There's no such ruling. But some really important things have happened. Here's what you actually need to know. First up, the Fourth Amendment. In May 2025, the Supreme Court made waves with a unanimous 9-0 decision in the case of Barnes v. Felix. Here's the scene. A Texas traffic stop turns chaotic. An officer, Felix, ends up shooting a man named Ashton Barnes as Barnes tries to drive away. Lower courts gave the officer a pass, saying they could only look at the exact split second when Felix pulled the trigger. But the Supreme Court said, no way. They tossed out that narrow rule. Now, when courts look at police use of deadly force, they have to consider everything, the whole chain of events, not just the last moment. This is called the totality of the circumstances test. Let's break that down. Before Barnes v. Felix, some courts focused only on the instant an officer fired their weapon, ignoring what led up to that moment. Critics argued this let officers off the hook too easily, especially in cases where their own actions escalated a situation. The Supreme Court's 9-0 decision changes that. Now, judges and juries must look at the entire encounter, what the officer did before, how the suspect behaved, and whether the officer's choices contributed to the danger. Legal experts say this ruling brings much-needed clarity. It sets a national standard, ending years of confusion and conflicting rulings in lower courts. Civil rights advocates are calling it a major victory, arguing it will make it easier to hold police accountable in excessive force cases. Professor Linda Martinez, a constitutional law scholar, explains, "This decision doesn't mean every police shooting will be found unconstitutional, but it does mean courts can't ignore the officer's conduct leading up to the use of force." Public reaction has been intense. Civil rights groups have praised the ruling, while some police unions worry it could make officers second-guess split-second decisions. On social media, the debate is fierce. Some see it as overdue reform, others as a threat to law enforcement. But what about the Second Amendment? Here's the straight answer: there's been no new 9-0 Supreme Court ruling on gun rights. Sure, the court declined to take up some big cases, like Minnesota's limits on young gun carriers and DC's ban on high-capacity magazines. And yes, the court did unanimously block a lawsuit from Mexico against American gun manufacturers, but that was all about legal immunity for gun makers, not about the Second Amendment itself. So, here's the real picture. For the Fourth Amendment, there's a big new precedent: Barnes v. Felix. For the Second Amendment, no new sweeping decision. The implications of Barnes v. Felix are far-reaching. Police departments nationwide will need to review their training and policies. Legal analysts predict more lawsuits challenging police conduct, and courts will have to grapple with the full context of each case. Some experts warn that while the ruling is a step forward, it's not a cure-all. Accountability still depends on how lower courts apply this standard, says attorney Marcus Lee, but it's a powerful tool for civil rights lawyers. And those viral YouTube videos hyping a 9-0 ruling covering both amendments? Totally bogus. There's simply no record of it, none, zip nada. Don't let sensational headlines fool you. Always double-check with credible legal news or actual Supreme Court documents if you want the facts. If you've got questions about Supreme Court rulings, or you want a breakdown of a specific case, drop it in the comments. I'll help you sort it out. Stay sharp out there, and don't believe everything that pops up in your feed. The Supreme Court's 9-0 ruling in Barnes v. Felix is a landmark for police accountability, but don't let misinformation cloud the facts. Now let's zoom out and put this 9-0 ruling into perspective. Unanimous Supreme Court decisions don't just happen, they send a powerful message. When all 9 justices, regardless of their political leanings, come together, it signals that the legal principle at stake is crystal clear. Looking back, some of the most influential rulings in history were unanimous. Take Brown v. Board of Education in 1954. All 9 justices agreed that racial segregation in public schools was unconstitutional, a decision that fueled the civil rights movement and changed the fabric of American society. Another example, United States v. Nixon in 1974. The court ruled 9-0 that President Nixon had to hand over the Watergate tapes, reinforcing that no one, not even the president, is above the law. And in more recent years, Riley v. California in 2014, the justices unanimously decided that police need a warrant to search your cell phone, a huge win for digital privacy rights in the modern era. These cases show that when the Supreme Court speaks with one voice, the impact can be profound, shaping law, policy, and public life for generations. That's why the Barnes v. Felix decision stands out. It joins a tradition of unanimous rulings that clarify the law and set nationwide standards. So, the next time you hear about a 9-0 Supreme Court decision, remember, it's not just a number. It's a rare moment of total agreement at the highest level, and it often marks a turning point in American legal history. Let's break down the Barnes v. Felix case at the center of this unanimous Supreme Court ruling. First, the basics. Barnes was a local resident who sued Officer Felix, claiming his civil rights were violated during a late-night traffic stop. Barnes argued that Felix used excessive force without clear justification, raising critical questions about police conduct and accountability. On the other side, Felix's legal team maintained that the officer acted within established procedures, citing concerns for officer safety and the unpredictability of nighttime stops. The core legal question, whether Felix could be held personally liable for his actions, or if qualified immunity, a doctrine that often shields officers from lawsuits, would apply. Both sides presented strong arguments. Barnes' attorneys emphasized the importance of holding law enforcement accountable for clear violations of constitutional rights. Felix's defense stressed the need for officers to make quick decisions without fear of constant litigation. The Supreme Court's 9-0 ruling cut through the noise. The justices unanimously found that Felix's actions did cross the line, and that qualified immunity did not apply in this case. Their reasoning was clear: the right to be free from excessive force is well established, and officers must be accountable when they step outside those boundaries. But the impact goes further. This decision sends a message to law enforcement agencies nationwide, reaffirming that constitutional rights cannot be ignored even in challenging or dangerous situations. For civil rights advocates, it's a win that strengthens protections for individuals and clarifies the limits of police authority. Barnes v. Felix isn't just about two people. It's about the balance between public safety and personal rights, and the ongoing evolution of American justice. In the wake of the Barnes v. Felix decision, another significant development has captured the attention of legal experts and the public alike. The Supreme Court recently declined to hear several high-profile Second Amendment cases, leaving many to wonder about the future of gun rights in America. First, let's clarify what these cases were about. They challenged various state and local gun control measures, from restrictions on carrying firearms in public to limits on magazine capacities. Gun rights advocates hoped these cases would provide a platform for the Supreme Court to further define the scope of the Second Amendment, particularly in relation to carrying guns outside the home. However, the court's decision not to hear these cases speaks volumes. By declining to take them up, the justices effectively left lower court rulings intact, many of which upheld the challenged restrictions. This move has significant implications. It suggests a reluctance from the Supreme Court to wade into the contentious and politically charged waters of gun control at this time. Why did the Supreme Court decline these cases? There are several possible reasons. One, the court may be waiting for a case that presents a clearer legal question or a more compelling set of facts. Two, the justices might be divided on the issue and prefer to avoid a ruling that could lead to a fractured decision. And three, the court could be signaling a preference for maintaining the status quo, allowing states and localities to navigate the complexities of gun regulation on their own. For gun rights advocates, this is a setback. They were hoping for a definitive ruling that would expand Second Amendment protections. On the other hand, supporters of gun control see this as a validation of existing laws and a green light for further regulatory efforts. The Supreme Court's decision not to engage with these cases doesn't mean the debate is over. Far from it. It simply shifts the battleground back to the states and lower courts, where the fight over gun rights and regulations will continue to evolve. In the grand scheme, this move underscores the delicate balance the Supreme Court must maintain between interpreting the Constitution and navigating the shifting tides of public opinion and legislative action. It's a reminder that while the court's rulings are final, the legal landscape is ever-changing, influenced by new cases, emerging issues, and the ongoing dialogue between the judiciary, lawmakers, and the public. As we look ahead, the Supreme Court's reticence on these Second Amendment cases leaves many questions unanswered, ensuring that the debate over gun rights in America is far from settled. The Supreme Court's recent choices have ignited a wave of responses from all corners of American society. Legal scholars, advocacy groups, and media outlets have all weighed in, offering diverse perspectives on what these decisions mean for the future. Legal experts are divided. Some see the court's restraint as a strategic move, an effort to avoid deepening political divides or issuing sweeping rulings that could unsettle established law. Professor Linda Chen from the University of Michigan notes, "By stepping back, the court is allowing the lower courts and legislatures to do the heavy lifting, at least for now." Others argue that the lack of clarity creates confusion and inconsistency across the country. Gun rights groups, such as the National Rifle Association, have expressed disappointment, calling the court's inaction a missed opportunity to solidify Second Amendment protections. In a statement, the NRA said, "Americans deserve clear guidance. The Supreme Court's silence leaves our rights vulnerable to a patchwork of state laws." Gun control advocates, on the other hand, celebrated the decisions. Organizations like Everytown for Gun Safety praised the court for deferring to state and local governments, viewing it as a win for public safety and legislative autonomy. Spokesperson Maria Torres remarked, "This is a victory for communities working to keep their citizens safe." The media landscape reflects this divide. Editorials in major newspapers range from cautious approval to outright frustration. Some outlets commend the court's prudence, while others fear the lack of definitive rulings will only intensify legal battles and public uncertainty. Social media, too, is abuzz with debate. Hashtags trend as Americans voice both relief and outrage, underscoring just how personal and polarizing these issues remain. As the dust settles, one thing is clear: the Supreme Court's decisions, or refusals to decide, have sparked a national conversation that goes far beyond the courtroom. The path forward remains uncertain, and the eyes of the nation continue to watch, waiting for the next chapter in this unfolding legal saga.